Cool.
Hi, so welcome back to Risk Management. Today we have the pleasure of talking with Magnus Steen, who's the former general counsel for Sony Ericsson and also now CEO of Contract Business Intelligence. He's going to be talking with us today about contract management in the context of legal risk management. So Magnus, thanks for joining us. Really appreciate your coming on.
No, thanks for having me here. It's really nice to be here and to talk about this, which has become a favorite subject of mine for quite some time now.
So tell us a little bit about how did you get into this and why is there a need for contract management? What is it that's important that we should know about? Why haven't we done contract management for the last 200 years? What's changing?
Yeah, we probably have done it, but maybe not as dedicated and as systematic as we should be doing it. But let me come back on that. So I'm a trained lawyer. I left the law school in the beginning of the 90s and started the normal path. At least in Sweden, you go to court for 2 years and then you get recruited to a law firm. And I did that for quite some time. And in the beginning of 2002, I think it was, I was recruited to become general counsel for the Swedish part of Sony Ericsson, then the newly created joint venture between Sony and Ericsson, which took over the handset business from both of the companies. The deal was structured as an asset deal, which from a contract perspective meant that the lawyers at Ericsson basically went to the cabinet files, pulled out 20,000 contracts in paper copies and put them on my desk. Welcome, Magnus, take care of this, and you figure out what you should be doing.
You all of a sudden realized that you needed to clone yourself about 8 times to handle what you'd just gotten.
Yeah, first of all, that, it was quite a revelation to me. First of all, I realized that no one actually cared about those documents. And for me as a lawyer, I was trained by, contracts are important. They are binding agreements, and we do them for real. We should, they should mean something. And there were just papers in piles lying around, and nobody cared. So my first task was basically to build an agreement database. And I took, of course, the idea of building something that was electronic. It was early days, internet was just founded, or a couple of years after it was founded. It was at the day when you basically scanning one page took 20 seconds. So 20,000 contracts, and say it was maybe 10, 15 pages each, it was a mastodontic work to be done. But basically we did it. It took some time. But we built a contract database with a limited number of metadata, but suddenly we had something that we could distribute. We could engage with the business and say, here are your contracts. You can start taking care of them. I must also say that I had a very interesting debate in the legal community at this time, where a lot of my colleagues basically said that, contracts, they are too important, too risky to share with common people. And, which common people? Those that are telling us that we should have contracts because they want to do business? You mean that they cannot read and understand the contract? No, but they can share it with each other. And yeah, a lot of things came up. But, my basic view has been, from the beginning, contracts belong with the business people. If they don't understand what's in the agreement, we have done something wrong. We lawyers have done something wrong. And, the whole debate about writing contracts for the users, readable, understandable contracts, it's such a given discussion. And I don't understand why any lawyer fights against it. Maybe protecting their own business, but otherwise, which other business would survive if they made products that were not easy to use and maybe not even made for the user? So, and that's part of the risk in contract as well. The other thing that became very apparent to me quite early was that we were we were 3 lawyers in my department to support basically the full procurement and purchasing and technology development business. And it was a huge task. And I realized, you know, if we have 20,000 contracts now and we're going to make 2,000 per year or whatever it was, you know, I can't cope with that. It was impossible to do. So what I realized quite early was that I needed to find a way to work with contracts with the business and basically make them do a lot of the work themselves. So distribute the burden to those that do it best. So, and even if I didn't put the word contract management on it at that time, that was basically what we built up. Approval instruction, who can negotiate, which template to use, what can we agree to, what can we not agree to, which question was decision by legal, by finance, by the business itself. Very simple, very rudimentary, but a very well working system. That actually meant that the legal department had a reasonable and decent working situation.
Sounds like part of what was going on was really just that understaffed to handle the volume of what you were dealing with, and you had to innovate in some ways to handle the volume, the complexity, and the transfer of knowledge to the business side of the house in a way that would be time efficient and resource efficient.
Yeah, I had no choice, basically. And here comes another angle on this. You know, getting to the right result is not always throwing more money or throwing more lawyers or throwing more papers on it. We have one example in the book that we have been writing together. That is about how we did how we reviewed how we work with NDA confidentiality agreements. And the starting point was that we wrote one NDA per project, per engagement, which led that we did 5,000 contracts a year. Mm. And when we have reviewed the risk situation around it, we concluded, you know, very little risk. We needed it because we had patent information and we needed to protect the novelty. Otherwise, we would lose the right to claim the patent. So it was important for us, but not in the way that we did it. And after that exercise, we landed on doing 250 each. And I think that when I calculated, I think we saved about 15,000 hours, valuable business hour per year, just by that exercise. And I would probably say that we had lower or at least the same risk position as we had before.
So walk me through this a little bit, how this contract management works, because I'm a lawyer too, and I'm not a contract expert, but from my recollection from my contract law days, a lot of times there's just a failure of the meeting of the minds that ultimately leads to the risk that crops up in a contract. There's a famous case in the United States called Frigidaire, which deals with a fight over what the definition of a chicken is. And some people arguing that it means one thing and others another. Aren't all contracts to some extent bespoke and sort of something that somebody got together with somebody else, made a deal, there was some sort of understanding at that time, and now we're left to pick up the pieces, maybe secondhand as the general counsel or the risk manager, trying to figure out and recreate for ourselves what the deal was, and then trying to enforce something that the other side certainly may not have in any way created that constellation in their minds. How do you do this systematically?
Yeah. First of all, if we take the risk perspective, because I will say that there are basically 3 categories. First of all, those that are standard, that they are basically, you know, this is a contract. You know, if you want to do business with it, you just accept it. You know, either by standardization in the business or by standardization by monopoly. You know, you really don't negotiate for a license with Microsoft. At least you and I wouldn't do it.
Right.
You know, they wouldn't care to do business with us. Of course, some have levels to even talk to Microsoft, but very few, I would say. So that becomes standard. That contract is in place in a sense. Then we have those that are largely standard. Most of it is standard, but you negotiate some deal-specific terms around it. I would say, for instance, M&A contracts, we treat them as bespoke, but if you compare the documents between different deals, I would say that 80% are more or less at least a standard. Which is a very interesting point on how you can make the legal market even more efficient by standardizing heavily. But that's another discussion that we can take at another time. But it's really interesting. And the third part is, of course, bespoke. And here is where we can heavily negotiate agreements that are more or less unique in all parts. Then we need to differentiate between legal language and deal-specific language. So if you take a purchasing agreement of a plant, you want to have a new factory installed turnkey at a site outside of the city. That is probably a very unique agreement down to the little detail. The legal part of that contract, or the legal text of that contract, is more or less standard. And that comes to probably one revelation that I made quite early during this period at Sony Ericsson, was that we had hardly any disputes around legal language, but we had a lot of issues around bad specifications to the agreement, where people failed to describe what do I want, when should it be delivered, and how shall we deal with changes. Probably the things that we as lawyers say, dear business guy, why don't you fix the exhibit? Here's the template. And the most document, you wouldn't go into a car dealer and say, hey, I want a car. You would probably say, I want that car, and I want it in this color, and I want these extras to it, and please deliver it at this time, and I want it before the summer season because I'm going on vacation with my family.
Right. Well, why is it that these terms don't get put into the contracts in the first place? What's going on that there's that breakdown? I mean, these are sort of the essentials, the substance of it. Why does that not show up in the deal?
Yeah, a lot of people do a lot of good work, but you need to understand that the contract cycle need to be reviewed from a holistic point of view, or this is a chain that cannot be broken. So let me take you through the contract management life cycle. So basically it starts with the idea, I want to do a contract, or I want to develop a business, or whatever. And if you haven't thought that through properly, what do I want? When do I want it? What are the budgets that I could use? And then you engage in the whole contract cycle. If you haven't figured that out, you will go wrong. So you have the idea, I want to purchase something. Take that as an example. And then you can either do it your own way, a bit maverick. I just go to somebody and say, I want to buy this. And you probably end up without an agreement. But you maybe get your stuff and you're happy. Or you pull out a contract from the drawer and you use that one. The problem was that template was about buying something completely different, so it doesn't really fit. So then you have an inconsistency in the agreement. So, but even if you have done the first part correctly, I really know what I want, but I use the wrong template. Okay, the chain is broken.
Yeah.
Okay. Now we say, okay, you have thought it through properly, you take the right template, but when you negotiate, you have a negotiation scope creep. So suddenly you had a very good business case when you started to do this, but during the negotiation, the margin erodes, or you didn't get what you want. But due to you being tired during the negotiation, you signed a deal that you didn't want. Once again, the chain is broken.
Yes.
Yeah. And it goes on and on and on. And
but that's more from the side of just bad business, isn't it, than the contract management side? Somebody messed up and signed a bad deal. And how do I, in the contract management phase, do I try to negotiate my way back out of that deal and say we don't like it now? Or what from the risk perspective can we do then?
So first of all contracts can be renegotiated. As simple as that.
Right.
If you're a really good lawyer or if you're a really good politician in your contract, you know, there is a lot of leverages to be used in the contract management process to get you back on track. So all bad news doesn't necessarily need to become bad at the end. But if you fail in one of the steps, let me take another example of this.
Yeah, let's keep going through the process because I think it's useful to talk about these different phases of contract management.
So now we talked about basic contract strategy. You know, what do we want? We talked about contract creation. How do we get the first draft in place? We talked about contract negotiation. And now we come into approvals and signing as the next step. You know, here we have the examples of people signing contracts they're not allowed to sign. So now, you know, I'm the head of a department, but our corporate rule says that all contracts should be signed by the president. And I sign it anyway. And when it comes to the president, half a year later, he says, you know, we're not bound by this. Different legislation under different jurisdictions. But basically, authorized signature is a quite strong rule in most jurisdictions to get to a binding agreement.
So this happens. People sign, and then it's discovered you had no authority, and now the company has to basically deny responsibility for the contract and break it.
Yeah, either live with it, which happens in a lot of cases. You know, most people do deals that the company wants to have. And they are driven businessmen and they are accepted for it. But you know, sometimes it's happened. Here where I live, we had a guy that was heading a sourcing department and went out and made a marketing deal with a local soccer club. And he even had a press conference announcing this. You know, and the company said, you know, they called the club up the day after, you know, he has no authority to give our money away.
Yeah.
One football company in Sweden, one really major stock exchange company in Sweden, and really backed off. So you need to have the authority with you when you do deals. And to be even more clear, this is probably not the most danger for the company, but for the individual that do deals that he doesn't have a mandate to do. You know, it's criminal.
Yeah. Does it ever happen that the countersigner to the contract, the other party, will say, we're not bound by this contract because the person didn't have authority to sign it?
I haven't been in that situation. The problem is it's sort of sitting on the other side because they can basically bless the contract afterwards.
I see.
Yeah.
So, you just wonder about sort of strategic negotiations here and trying to claim inability to sign and so forth. But
yeah, what you could do is, of course, put pressure on the individual. So that it could be sort of, you can land in a blackmailing situation.
Yeah.
So, you know, I will tell you, boss, that you signed this deal without doing this and this, and of course that is not recommendable to do.
Right, of course not. But again, it creates, if you don't have that authority, it creates potential risk situations like this, where in fact you can have blackmail or something else going on, and the company is held hostage as a result of not having these proper authority chains in place.
Yeah. So the authority chain and approval and signing is sometimes feels like an administrative burden, but it actually is one of the core elements in a contracting process. And it's about to getting decisions made on the right level. However, if you implement this wrongly in the company, you will just build a very, very long and cumbersome process to get to approvals. So it is about to get decision level on the right level, decisions on the right level.
And how should that be divvied up? How if a company has an org chart, sort of, you know, we've got the CEO up here and the CFO and the CLO and so forth, how do we decide what level of complexity of contract to give to what level in that org chart?
So one normal path is, of course, to use a financial, you know, a deal level or something like that. You know, $100,000, business manager, $1 million, local CEO, 10 million, and so on. However, with contracts, you have an additional layer of complexity that you need to cater for as well. For instance, you can have frame agreements, which per se has zero value, but could have a very, very low value at the end. You could have certain obligations under the agreement that could be actually quite burdensome or expose the company, such as hyper positions or indemnity clauses, liability or non-liability clauses, etc., which caters for another approval order than the ordinary one. And here you can connect it, for instance, to the legal department having reviewed the agreement before the financial approval is made or something like that. Mm-hmm. My position comes back to how I see that the contract management process should be set up. I think that the ownership of each contract must reside with the business unit that is responsible for executing it. And therefore, the approval should also be connected to that level or maybe the level above. But if you get too distant from where the business is done, then the people will just sign in blindness because they have no idea and understanding what's about. So if the president for Google should sign every deal within Google, he has no clue on what he's signing. He simply cannot have that. So you need to get distributed approval to the right level. Mm-hmm. Mm-hmm. Otherwise, that becomes a risk per se as well.
Sure. And who is this something that the general counsel should be in charge of divvying up this process, or who should figure out what level has appropriate authority? Is this a CEO or C-suite decision?
Yeah, it's a C-suite decision, and I would probably say it's a cooperation between general counsel and the CFO.
Mm-hmm. Yeah. Okay, so we've got outlining the agreement and the negotiation, and then really we've talked about execution here. What comes after that?
So when we signed, everyone pulls out the champagne from the refrigerator and say, yes, we did it, and they sign it, and everyone's happy. And in a lot of companies, the copy of the contract goes into the drawer. And then we start doing business and everyone's happy, and we do it, and no one reads the contract. We spend a fortune on getting to the deal. You know, lawyers are expensive in the US as well, I've heard.
Yeah.
Yeah. And even if they're in-house, they're still expensive resources. And we travel and we draft and we write and we negotiate, you know, quite some investment into these documents. And then we pass them into the drawer. That tells me two things. Otherwise, we should stop doing that, simplify the deal making. If we're just going to put them in the drawer, we can maybe do it on a one-pager instead. Or we try to use them as the documents that should be, as the guideline for how we should live with the deal. Because we have written in the contract, you shall be doing this, and I shall be doing this. You should deliver on Monday, and it should be of this quality, etc. This is what we should measure against. So here comes the next step in the contract. It's about handing it over to an operational, you know, moving it into monitoring, performance follow-up, ensuring that we meet our obligation, ensuring that the counterpart is meeting the obligations, you know, living with the contracts. when there comes changes, because that is the only thing we know, life is going to change, then we also need to take care of the changes in the agreement. Because most agree, if you're sitting in a development or an outsourcing deal, the deal is obsolete at the day of signing because things have changed.
Yeah.
Which means that you need to have a totally other view on how you work with contract. That kind of contract is only a book of how we work together rather than a specified delivery.
How do we deal with the fact that, as you point out, there's always change going on and circumstances are not going to stay the way they were at the time we struck the deal? And so there's a certain amount of, you could call it oral negotiation or follow-up, sort of tacit flexibility given to the contract to meet circumstances that have changed, where the contract doesn't get updated. As you point out, it sits in the drawer, but circumstances are changing constantly even after that thing was signed. How do we stick with that original agreement without constant updating, which might also be expensive and sort of time prohibitive or cost prohibitive given the level of change going on?
It's a very, very good question. And I really would like to have a silver bullet to this question. But what I would say is that, and here you come into, you need to have your organization understanding how this works, because we cannot document all deviations as a legal contract. Simply will not work. So we need to educate people on take notes, write a mail to confirm the change, drop it into our central repositories, we keep it, set up a structure. If you have a large development project, for as an example, build a process on how you deal with changes, so that is actually being dealt with by somebody in a process where it's documented.
So really what I'm hearing you say is, although we can't necessarily expend the resources for continual updating the contract, at least document to some extent any sort of notable change that's coming about that might have some potential influence on the original deal.
Yeah. And then of course you come to a point where you sort of conclude that, okay, what we have written is so obsolete that we really need to do something about it, a renegotiation or whatever it is. But I would say that the best practice is probably that you build in mechanism in how you work under the contract to have a process for change in all these dimensions that you need, which is cost, scope, and timeline. And if you have that as a process under the agreement, as saying that should be recorded at minutes of meeting, which both parties should recognize by exchanging an email. Then you have a process for updating the agreement, but not the sort of the legal way.
A couple of things come to mind. One is, in the book, you talk a little bit about how you're opposed to evergreen contracts, that you feel that all contracts to some extent should have sunset provisions in them and a time period for renegotiation. Is that just exactly for the reasons that we're dealing with, that at some point the evolution of time, resources, the business are such that the original contract is no longer recognizable against the current reality?
I would say that this is part of it depends on which side you are. So one part of me says that we should do it as simple as we ever can, so we can expedite all contracting. On the other hand, I'm also aware of that sometimes it's actually better for me to write contracts that are more beneficial to me. And having if I'm a sales guy and I have a contract that just runs on and on and on and on, pretty good for me. Of course, what I should do as a professional is to monitor from my side whether that contract is still beneficial to me, or whether it may land in a situation where it becomes so obscure that nobody really understands what it is. But there, of course, you need to weigh these different positions and decide what you want to run.
But we may not know in advance which one's better for us, right? When we're writing the contract, whether we're going to set a time period into it or not, maybe something only after the fact that we figure out which way we wanted to go.
No, and there are a lot of contracts that are actually too long. So I have personally, I've taken the position over the last couple of years that I write shorter and shorter agreements.
Yeah. So, okay, so we've gone through sort of the negotiation, the execution, deployment, the management we're really talking about here. What comes after that?
Then you come to the position, should I change the current agreement? Should I terminate it? Or should I restart it? So basically, you've gone the full circle. And here comes in the interesting part, which a lot of companies actually do not do. They are not properly analyzing the performance under the contract. So is this a good agreement for us or not? And there are some lawyers who have such deep knowledge into their specific market that actually can tell, market standard is like this. But most of us don't. We do this from a gut feeling or putting, let's see where the wind is blowing. Should it be 25% liability or should it be 35? It became 25. Okay. So this kind of analytics, bringing that into the pieces, it's going to be really, really interesting now that we get tools soon. They may be already on the market that actually can read and compare agreements over full portfolio. So interesting to see.
Yeah, what's going to happen with that? You had mentioned in the book a little bit about AI and the possibility that we might be able to use artificial intelligence in some ways to create not just contract terms, but also the management of it thereafter to sort of update, measure market processes, measure business enterprise statistics and so forth, and sort of create real-time contracting? Is that how it's going to look, or what's going to happen?
First of all, what is going to happen the next coming year is that we will get machines that can read and understand the contracts. So basically, they will be able to pick up, and they can already do that, pick up which clauses are what kind of clauses. This is a limitation of liability clause. In a couple of year times, it's also going to be able to evaluate that, whether it's a good or bad provision. Going to compare it to other clauses in a huge subset of agreements, saying that this is a customary or this is I've never seen before kind of writing. And that will develop, and that will also build tools connected to that, saying that if you have this clause here, I propose that you maybe insert this one as well. This one I've never seen before, maybe use this one instead when you draft. This will also, I believe, drive a standardization. My gut feeling, and you may say that I'm wrong, but let's say there are only 10 variants of a limitation of liability clause. And of course, there's a lot of different wordings around it, but the essence of the clauses, 10 variants. Compared to the Incoterms, they are built up, there are, 10, 15 variants?
Yeah.
DDP to X-Works to free on board. Standardized, you just put that language in the contract. Everyone knows what it's about. You can do that basically for all clauses in a contract. Which then would lead to that the contracting would be much, much simpler. Okay, limitation liability, should we have a number 1, 2, 3, or 4? Let's take number 2. Good.
I'm a fan of, this goes back to what we were talking about before with the definition of a chicken and so forth, and the subtleties that come in there. Wittgenstein said that language is sort of what you make of it, right? That there isn't necessarily a shared understanding, that everybody has their own unique language without a universal. How are we expecting, if we're going to have machines that consolidate this and put us in the straitjacket of options 1, 2, 3, 4, 5, or 6, and you can order off the menu for these. Humans are sort of infinitely complex in how they arrange things. Are we going to put constraints on industry, on business, such that they can't create those bespoke flexibilities? Is it going to shrink opportunity for innovation?
It's a very interesting aspect, because I think that probably the contract as such is a fantastic tool to be flexible, because you can stretch it in whatever direction you want to, of course within certain frames, but it is a very, very flexible tool to work with to create business. What I would say that when I look upon a contract, I directly can say that, 80% of this is just standard, but we are not standardizing it. We are inventing it time after time after time. So I had a discussion with a researcher here in Sweden the other week, and he said, why isn't this happening already now in the legal industry? And I said, the problem with us lawyers is we're not industrialized, and industrialists, we are carpenters. We like to build, and we actually like to make it our way. Maybe even more artists who want to do it our way. So,
yeah, so what you're saying is this is really the industrial revolution for law, that what we're ultimately doing is mechanizing the parts that any artisan, if you will, would be doing over and over and over again in exactly the same way. These are the basic bricks that we make for the building. Yeah. And you bake a brick in an oven at a certain temperature each time. We don't need a human to do that. That can be done by a machine, but any bespoke parts we could still reserve for the humans to negotiate.
Yeah, and we're not going to take humans out of the process. Absolutely not. So this is going to take over a piece of the work, and from efficiency point of view, should be taken over.
Yeah, yeah.
Let me. It's not about the legal industry as such. It's about contracting.
Yeah.
It's probably going to happen other stuff in other areas of the legal industry as well. But what I've seen so far about the digitalization of the legal industry, if you look upon e-discovery as an example, is that has not really led to any market efficiency. It actually only led to more billable hours.
So you think that this will actually, as a lawyer, if I'm a transactional attorney and AI comes in and I'm in the business of writing contracts for firms, M&As or whatever, if it's coming out, what does my business look like as I integrate the AI into it? What will I spend my time doing after that?
So my prediction on the legal market is that it will go two ways. One way is going to be very, very much cost pressured by automatization, by legal business process outsourcing, etc. So that will drive that part of the market into a lower value service. The other part is the bespoke part, which is going to drive the true expert, the true personal advisors, bespoke advisors to be even in a higher paid range. So if you look upon the law firms, it's going to be very, very clearly like they cannot charge full billable hour for all work. It's going to be divided into buckets. But I think I'm pretty clear on that prediction, that I believe in that.
And not just because of the AI, but also because of, say, legal process outsourcers or paralegals or anything like that, also taking over that work?
It will be part of the competition setup, because those will, with the help of these tools, they will have a better ability to compete. And they will then really start using price as the competition tool.
Does this contract management apply only to large, complex companies? Or if I'm a small business, 30, 40 employees, maybe I don't even have a general counsel, right? I just sort of call on an attorney once in a while. How do I, if I'm in a small business, avail myself of services like yours to be able to manage my contract flow better? How is that going to look on the small scale?
First of all, the process is the same. What is good with the small companies that we all sit around the same table. So you don't really have a process for it. But it's the same kind of activities that needs to be done. You still need to think about monitoring that you get the value out of the contract. And you need to set up that so you understand that that is part of the contracting. But you know, a small company, most of the things are anyway in the head. I don't really need to put it in a system or something like that. But as soon as you grow, I would say somewhere beyond 200-300 employees, 500 contracts, yeah, that becomes difficult. You can compare it with your accounting system. You know, even if you're a small company, you can probably still have it in paper, but no one will do it because it's inefficient.
Mm-hmm. Yeah, that's very interesting. Do you have any, here's a time to sort of turn it open to some of the stories that you may have that you want to share with us, things that are coming to mind as we've talked about where you've seen pitfalls in the industry so far, where people need to be better in terms of their contract management. I know we have in the book a number of examples there, but in recent times, are you seeing trends that need to be addressed?
I think there's one interesting trend that is going on right now is that, and it comes as a backlash on the there was a huge price pressure going on in all negotiations during the first couple of years after the millennium. So basically, it was only about price. Price is interesting, of course, but it doesn't have the value element of it. And in a lot of business, the margins are so thin now, so you cannot really drive anymore from just price pressure or cost pressure. And we see this in a lot of instances. You know, you come back to that people are not, you know, properly paid for the works that are surfacing, etc. And you have minimum wages, etc. But the pressure is so hard on everything and all instances. So we lose the value by just talking cost. So one emerging, and it's been now for a couple of years, is about talking about relationship-based contracting. You know, how can we do this better together? How can this be a win-win solution? And there's a new paper from IACCM, the International Association of Contract and Commercial Management, that is just about this. How can you use your contract in a more relationship-based, and that means that it's not based on collision, it's based on cooperation. And you can probably see this, you know, I've said it many times that most contracts are better negotiated without lawyers in the room. And that it's nothing against the lawyers, they contribute to the deal, but they are also contributing to the atmosphere in the negotiation. Because they are risk avert and they want to really protect their client. So they take a position to protect their client in the negotiation. Of course, I'm generalizing now.
Yeah.
But instead of saying, you know, how can we drive this cooperation to be best for both parties, where we can have 1 + 1 becomes 3, and we share 3 instead of one beats the other and we maybe share 0.5. Because of course the first alternative is much more interesting. So it's a really good theory behind it, and it works well when you get companies that are mature enough to deal with it, and you can take a lot of steps in the meantime before you get to sort of full-blown model of a relationship-based contracting. But
does the relationship-based contracting extend not just to the negotiation and execution phase, but also to the management phase?
Absolutely. You know, a contract, the end of the contract is not the signature. That is the starting point. So it's more important after, and of course, it's more relevant in long-term complex relationships than it is in, you know, one-off deals. If you do one-off deals, then more or less you can screw your partner as much as you want because he won't come back to you anyway. If you have a long-term relationship, you really need your counterpart to be as happy as you are.
Yeah, yeah. And so to some extent, that relation-based management may also take contracts out of the realm of being one-off contracts and allow for opportunities to build more relational long-term arrangements.
Yeah. So they are typically used where you need to drive innovation. And innovation is not just, you know, disruption. It's basically all kind of ways where we can do it better than we do it today. You know, how can we jointly increase margin? How can we jointly reduce cost? Because you're just telling the other party, please come down in price. It's not really reducing the cost. It's just eroding his margin. And, you know, if you have a counterparty that makes no margin on doing business with you, he will leave you. Go to somebody where he has margin.
Yeah.
You can help each other to get to a better position. That is, of course, a nice thought. So that is one thing that I see is emerging. And it's going to be an interesting couple of years here now to see whether that model really bites. What I do see is that I see very few companies that are mature enough to take this step because it actually needs a change in your mind on how you do business.
Tell us a little bit about yourself with Contract Business Intelligence. This is your opportunity to tell the students a little bit about how somebody like you with your prestigious background has evolved and how you see a firm like yours positioning itself in the future.
Yeah, so basically, I believe that, you know, first of all, I've come to the conclusion that most companies have a huge potential in getting better contracting in place. So IACCM's investigation points at, you know, 9% of the turnover could be found in the bottom line if you increase your performance in contracting. It's a lot of money. So basically that is, you know, and I've seen it, you know, every company I meet, you know, they don't know what their contracts are, they don't know how to negotiate, they don't know. And these are skilled people, but they're not getting the picture together. Basically, that's what we do. We meet companies, we talk to them, we take them through this cycle. We start on a very low level. You know, no one will be able to fly to the moon day one. Step by step, in all the disciplines that we've gone through today, from how do we form a strategy, what templates should we be using, how do we negotiate, do we have approval structure in place, how do we ensure that we get a transfer from selling side to delivery side, how do we do performance follow-up, etc., etc. And how do we connect this into the processes? And I would say that we have a really, really good turnout on what we're doing. And just from getting frustration out of the process, because people are frustrated about this. You know, a turnaround time with the legal department of 3 weeks to answer a question. No one becomes hero with that. So it's a lot of things. So that is what we're doing. We're doing everything from small projects, you know, just fix my templates, to sit next to the general counsel and whisper in his ear what he should be doing over a 3-period time. Because some of this is transformation projects. The tricky part with this contract management process, I would say, is really 2 things. First thing is there is no truly designated owner of the contract management process. I am arguing that the general counsel is in the best position to take up this lead. I am challenged on this from quite some general counsel, because they are really, really afraid that they take over an administrative burden. To be sitting, you know, should I be walking around with the contracts and have them signed? No, I'm not saying you should design the process. You should ensure that you are part of the relevant lead, or you have something really deal with. The rest should be outsourced to the business, to a LPO or whatever. So this is also a process that actually can help the legal department to get into the driving seat of the most important things to do in the company. Secondly, the other thing that makes it complex, it is a true cross-company, cross-functional process. It is not just what we do in legal. It goes through the whole company and everyone, more or less, is involved. From each business unit, sales side to delivery, to CEO, CFO, CTO, and the legal department, and sourcing, whatever you can come up with. So that makes it complex. On the other hand, to me, it means for the general counsel that he has a true position of putting himself in the value creation of the company and leave the role of just being somebody you call when the ship has hit the fan. So to me, this is an offer or the greatest opportunity for the general counsel to actually be what he's asking to be. I want to be a business guy. I want to be part of the business making. You know, if you do this properly, the legal counsel can start reporting on a KPI based. Say, we have 5 deals in the pipeline. We expect them to be closed by year end. That will drive an additional quarter end result by $10 million to the company. Very few general counsel that can do that today.
Yeah.
He reports on today, we have this litigation that's really shitty. It's probably going to cost us a lot of more money.
Yeah. Yeah. Without quantification, estimates, or anything like that.
Yeah. And if he had had a proper contract and managed that very, very properly, he could probably have avoided the conflict.
How long does this audit process take to restructure a company and get it up to speed the way you're describing it with all these steps?
Of course, and now you get.
I know that's a very variable number, but give us a range.
So an analysis of a not too big sized company takes roughly 1 to 2 months, and then you have a pretty good view on the maturity of the company. Then you, depending on which, if you don't have any agreement database or contract management system in place, then you really need to, get your legacy contracts in place. That is the first project you need to run. But and that can take, depending on how far you want to go. But that can be up and running in a couple of months' time. So after that, I would say that you can start your transformation. And then it's about how much time and speed you want. So I would say you can do quite a good turnaround in a year and get a really good position. Then, of course, during this period of time, you can take small steps to just do a lot of stuff. Just fixing the approval process. It takes a lot of time and energy out of the organization and the frustration.
So let me ask this. If a company is in a sort of a tumultuous or volatile time, is that the best time to start doing this, where there might be turnover in the employees, you lose that institutional memory of what's going on? And how do you handle those circumstances?
So here comes another part. The contract, even if I'm saying that the contract management process is not working in companies, it sort of works anyway. Companies are alive out there and they're doing money, making money, etc.
Yeah.
Sense of urgency and motivation is very much needed to make this process happen, because it sits in a lot of different places, and you really need to get people. But if your margins are too low, contract management is a process where you can drive it up with several percentages. Which CFO, wouldn't want the promise of getting another 10% extra on the bottom line?
Sure.
I would probably say that he's stupid of not doing it.
Right.
Sure.
Sure.
Yeah.
This is great. Is there, we're sort of wrapping up towards the close here after an hour. Tell us anything more. This is a group of motivated students who are all, to some extent, familiar with law, not all necessarily lawyers. What should they be thinking about in terms of gaining experience, becoming proficient in these abilities, besides listening to you and the other experts? How can they get better at this?
First of all, I would say find out which role you are playing in the contract management process, because you are part of it. So if you sit as a project leader for a development project where you have third parties contributing, you are leading the work. You have probably the most important role in the contract management process for that contract, because you're deciding about scope, timeline, and cost. And so we all play a part in this. We need to understand that we're doing that. So that is one starting point. And then, what can I do to help? How can I develop for us to be better? So the people in the invoicing department, they're part of this process. The persons in the delivery and goods receipt is part of this. So there's a lot of things that can be done from that perspective. Secondly, I would recommend simplification. Don't overdo anything of this. Cut it down to a bare minimum. Make it as simple as possible. In most instances, you will gain from that, rather than trying to be uber smart or something like that.
That's great. Okay, well, I think we're sort of wrapped up here for the time. Magnus Steen, thank you very much, CEO, Contract Business Intelligence, for joining us here in our risk management course. And if students want to get in touch with you, I assume they can, and that you would welcome hearing from them.
Or find me on LinkedIn or whatever. Pick up the phone.
That's great. Thanks very much, Magnus. Appreciate your time.
Take care.
Bye-bye.